We'll call our next case, Marion versus Grand Trunk Western. Mini oral argument on the application, 20-minute argument per side.
Have a stopwatch going
Okay. Okay.
by the ever-friendly, ever-helpful Mr. Royster. So, for my 2 minutes, may it please the court, Mary O'Donnell representing the defendant appellants. I'm joined by my colleague Jeremy Birdsall. I ask for 5 minutes for rebuttal. The application should be granted for 2 reasons. Reason 1, conflicts with a century of this court's precedents, which hold that train crews, upon seeing a trespasser not under disability on the tracks, have the legal right to presume that he will heed the warnings given and step off the tracks. Only when it is apparent that he either cannot or will not step to safety does a duty to arise to stop or slow. The supplemental briefing on the application indicates the parties' agreement on the controlling law as just articulated. The Court of Appeals' seeming disregard for this law is impermissible, requiring reversible. Reason 2, the decision regards at least 8 critical, undisputed facts and is thus clearly erroneous and causes material injustice. 1, Mr. Marion was 14 years old and, unbeknownst to the train crew, was wearing earbuds and listening to music. When the crew first saw him, he was between the rails approximately a mile away. No warnings had then been issued. Thus, there was nothing for Mr. Marion to respond to when the locomotive was a mile away. Critical, undisputed fact number 2, the train was going 29 miles per hour, approximately 43 feet per second. 3, the horn first started 18 to 19 seconds before impact, and the first blast lasted 2 seconds. 4, after perceiving Mr. Marion's non-response, the engineer put the train into emergency. 5, plaintiff's expert Beal says it took the train 715.9 feet to stop after the emergency application. 6, when the train is 715.9 feet from impact, it is 16.64 seconds away. 7, therefore the train must be put into emergency 16.64 seconds before impact to avoid the collision, unless Mr. Marion does this. 8, since the first horn blast concludes at 17 seconds before impact, the crew has 0.36 seconds to 1, give Mr. Marion time to respond to the horn. 2, assess his reaction. 3, decide whether he's going to step off the tracks. And 4, finally engage the emergency brake when Mr. Marion, did not step off the track. On these undisputed facts and this court's longstanding precedents, there's no genuine issue of material fact, and summary disposition is required. Therefore, defendants request that this court grant the application, reverse and vacate the Court of Appeals decision, and reinstate summary disposition.
You agree the presumption is rebuttable, right?
I agree, Justice Zara, that the presumption exists and that it dissipates or is overcome when it is apparent that the trespasser will not move to safety.
You indicated an undisputed fact is that the first sound of the horn was 18 to 19 seconds
Yes.
before impact.
I'm sorry?
18 to 19 seconds before impact is
Yes.
when you sounded the horn.
Yes.
Had you sounded the horn 40 seconds before impact, perhaps you would have discovered earlier that this person was not able to hear the horn, correct?
Well, yes, but
I mean, that's
that would have been,
unrebuttable, right? I mean, it's uncontestable. Had you done it, you might have discovered sooner, right?
well, had we not been running our train, we wouldn't have hit him. But the federal law, 49 CFR 222.21, says that, this is federal law, that the locomotive horn shall begin to be sounded at least 15 seconds, but not more than 20 seconds before the locomotive enters the crossing. So the crew is prohibited by federal law from sounding its horn at 40 seconds.
That regulation relates to an intersection with vehicles, correct?
Yes, Yes.
Is there a regulation that says you can't blow the horn if you see someone walking on the tracks?
Well, there is not.
Okay.
But the
So
subsequent.
you're fighting me, and I haven't even gotten to my question yet.
No, I'm not fighting with you, Judge. I'm just enjoying the exchange that we're having.
I guess the question I have is, what takes it out of the realm of being a question of fact for jury resolution that 18 to 19 seconds was the right time to blow that horn?
Well, first of all, when they first saw him a mile away, he was just walking on the track. There was no indication that he had any disability.
I'm not disagreeing with you.
And this court's precedence is that there's no duty to stop, slow, or sound the horn unless it becomes apparent that he's not going to move off the track.
I'm still agreeing with you.
I'm sorry?
I still agree with you.
Okay.
The question, though, is why is 18 to 19 seconds the right time to first try to warn this person and not something earlier?
Well,
or
again,
something even later? Why is it that that number is something that will allow the court to enter judgment in your favor, as opposed to perhaps a jury should consider whether they should have blown the horn sooner, such that they would have discovered sooner that this person wasn't going to get off the track?
Well, there has to be a basis for imposing upon the railroad a duty to sound the horn sooner. And this court's precedents, going back 100 years, have held that there's no duty to sound the horn or give warnings unless it's apparent that there's a disability and he's not going to move off. So there's no legal basis.
But isn't that sort of circular? How do you know that you have a basis to understand that he's not going to get off the tracks unless you sound your horn and see that he doesn't get off the tracks?
Okay, because first of all, the crew said that this happens, that they do see occasionally trespassers on the tracks, and they move off the track because it's common sense and reasonable. Travel on them. So, according to this court's precedent, is entitled to rely on the presumption that a person, in the exercise of ordinary care and to protect themselves, is going to move out of the way of a train.
Well, they say they can presume the person will get off the tracks until a reasonable person would recognize that the person is not responding to warning signs, removing himself from danger. So you say, you just said it's not uncommon for people to step aside without horns, right? Is the fact that he wasn't stepping off the track, even without a warning, sufficient to have put them on notice that this is, until the reasonable person would recognize he's not getting off the track?
Absolutely not. This court, in its holdings and its cases, has said that if we, the court system, were to require locomotives to sound horns, stop and slow, that would throw the entire system off, because they are entitled to presume that people will protect themselves and move off the track.
100%, we all agree. I think the point is how can we decide as a matter of law that at this particular, how the facts went down in this case is that they couldn't have blown the horn earlier. They didn't, the presumption wasn't rebutted at an earlier point.
Well, the federal regulation says 15 to 20. You can't sound the horn more than 20 seconds before you get to a crossing.
Apples and
And
oranges.
he was north of the crossing. I'm sorry?
Apples and oranges. That regulation relates to blowing the horn at an automotive cross-section.
Right.
Not a regulation as to when you can blow the horn when a person is walking on the track.
Well, yes, but according to this court's precedent, there's no duty to do that. 100 years of precedent.
There's no duty to do it until you know that the
Correct.
person's not going to respond.
Well, first of all, there's
Correct?
a duty to
That's
sound.
the duty.
Well,
Once you
there's-
know, then you
Yes.
have a duty.
Yes.
And I guess the question I have is, how do we determine when it becomes a matter of law that you gave enough notice to then determine that the person wasn't going to come off the track? I mean, what if you didn't blow the horn? I would imagine anybody who could hear would have gotten off the track. You could have waited 10 seconds, right? You could have waited 5 seconds? I don't know. Why is 18 to 19 a legal standard that says this is when it was appropriate without even asking a jury whether that was reasonable? That's my question. It's not a ruling, it's my question. Help me get past this.
Okay, so factually, Mr. Marion is north of the crossing. And when the horn was sounded, we're 19 seconds away from impact. And pursuant to the federal reg, the most you can sound is 20 seconds before you get to the crossing. Before that, under this court's precedent, the crew had a right to presume that this trespasser would get off the track. That is the legal standard by which the train crew governed itself, that they have a right to presume. There is no dispute that the train crew was maintaining a constant lookout at him. And when they see him a mile away, look out, you see someone a mile away, you don't know that he's got earbuds, that he's listening to music. You can see him, but barely see him. You can't see any response. You don't know whether he would respond or even, in this case, hear that horn. He didn't hear the horn at 19 seconds. He didn't hear the horn. They sounded the horn continuously for 6 seconds before impact. Mr. Marion had 19 seconds to move off the track. The last 6 seconds before impact, he could have moved off the track.
What about the testimony that says 3/4 of a mile down the track, somebody is on the track and he's not responding? I don't think he's going to move.
Yes, there was that testimony, but it was clarified
Okay.
that when that exchange occurred between the engineer and the conductor, they were right at the crossing. And that is Engineer Wilson, at the last page of his deposition, said that we recognized that he wasn't responding right at the crossing. And then my partner asked the question, after you sounded the horn? Yes. The exchange between the engineer and the conductor was after 19 seconds, after they sounded the horn. Yes, Justice Kavanaugh, it is true that earlier there was some confusion about when that exchange took place. But Engineer Wilson clarified it on the very last page of his deposition. My partner was very clear on that. And it was clear that that exchange took place at the crossing after the horn was sounded at 19 seconds.
Well, and presumably, if he says he's not responding, the horn hasn't been blown for him for something to respond to.
Exactly, Justice Kavanaugh. And that has been the point all along, which is when Mr. Wilson said that the exchange took place back when we first saw him, it's completely nonsensical because there was nothing to which Mr. Marion would respond. The horn, as Justice Zara has pointed out, wasn't sounded until 19 seconds. So there was nothing to respond to. So that exchange where he said he's not responding had to have occurred after 19 seconds because that's the first warning given.
Can I back up to when you had said earlier that, that even without the horns, or that most people would get off the tracks?
Yes.
Based on what?
Well, Engineer Wilson and Conductor Golembeski both proffered affidavits which are attached to the motion for summary disposition. And they say in their years of experience, they see people who use the track and they step off.
So the fact that this young man did not, why isn't that suggesting of giving the conductor notice that he wasn't getting off the track? If 9 times out of 10 or 99% of the time, without even warning, people get off the track because they know it's a dangerous thing to do, right?
There's no evidence.
And they see him a mile away, and maybe they're not even allowed, as you suggest under the statute, to blow the horn any earlier than 20 seconds before. But if 99% of the time people get off the track and this kid is not getting off the track, Why isn't that sufficient to rebut the presumption of saying until you have, a reasonable person would know he's not getting off?
19 seconds,
Why not earlier?
well, because of this court's precedent that they have the right to.
I'm sorry, can you use the microphone? Sorry.
I'm sorry. Thank you, Chief Justice. I apologize. At 19 seconds, they're going 43 feet per second. That's how far away they are from him. He still has adequate time.
Your rebuttal time.
He still has adequate time to get off the track.
Okay.
And they are entitled, and forgive me, I'm very honored to be in this courtroom in front of you. The importance of Supreme Court precedent is not to be understated. These crew members, they struck a 14-year-old boy. That affects them for the rest of their lives. They are relying on justice and courts, trial courts, Court of Appeals, this court, relying on precedent. And the precedent is that they had the right to presume until it became apparent. That's the magic phrase. Until it became apparent. It was not apparent. It was not apparent to the crew that Mr. Marion, a 14-year-old high
Counsel, good
school
morning.
freshman.
Just a question. At what point does it become apparent?
Thank you, Justice Bernstein. It becomes apparent at 19 seconds, which the first horn blast is sounded at 19 seconds. And the event recorder shows it goes for 2 seconds. So here's the crew watching him, exercising reasonable care. They see a person walking on the track. They sound the horn. The first blast goes for 2 seconds. They're now down to 17 seconds. They have to make this human decision. They have to give him time to respond. They have to perceive whether he's responded. They have to decide, oh, he's not responding. And then they have to they apply the emergency brake.
Isn't that window there, isn't that a fact question?
No, Your Honor, Justice Welch, no, because Mr. Beal, the plaintiff's expert, testified that the horn was sounded at 19 seconds. And the undisputed fact is that Mr. Marion gave no signal that he was under any disability. And under this court's precedent, the crew had the right to presume. So no, there's no question of fact, because it sounded at 19 seconds. It goes for 2 seconds. We all know that.
I just want you to know you're eating into your rebuttal time.
Oh,
You can continue,
thank you.
or you can save 2 minutes.
Thank you. Is that what I'm down to, 18 now?
2 minutes, and it's going again. Now it's 1:55, 54.
If I may, you're right. That was my job to.
Go over there.
To watch myself.
We don't want it
Thank
to
you,
start
Justice
ticking
Sarah.
again.
Thank you.
Morning. Nicholas Serino on behalf of the plaintiff, P number 37418. I'd like to spend 5 minutes of my 20 basically going over some of the actual facts and testimony and evidence, and which really does contradict what's already been said here. The very first witness in this case was the engineer, okay? Engineer Wilson. I'm going to quote what his testimony was. You mentioned that at some point, 20 to 25 seconds before impact, you realized he wasn't hearing the horns, correct? So if engineer Wilson is correct, then he didn't abide by the 19-second rule if he was between 20 and 25 seconds. I assumed he wasn't hearing the horn because he wasn't responding. That's the answer. Question. Do you remember any conversation that you might have been having with Mr. Golembeski at that time? Answer. He was saying that there's somebody is on the track and he's not responding. I don't think he's going to move. Question. When did that sort of conversation first occur? Answer. That was at the beginning, when we first saw him. You said you first saw him like 3/4 of a mile to a mile down the track? Then defense counsel tried to interject. No, he said that was visibility, and Engineer Wilson immediately said, no, we could see him. Now, there's a lot of significance to that. She's not even denying that they could see him from a mile away. But when the next deposition took place, and that was conductor Golombeski, he was simply asked, when you first saw him on the tracks, did you make any comment, if you recall, to Mr. Wilson, who was driving the train, saying, hey, there's a kid on the tracks? Answer, yeah. I probably said to him, there's somebody on the tracks, and he said, yeah, I see him, you know? So there's a conversation that takes place when they see him literally a mile going in the same direction, walking in the exact same direction as that train. This becomes very important because our expert, Richard Beal, and I'm going to go with, if we assume that the first time they sounded the horn was 19 or 20 seconds, if we make that assumption, and it's all on the video from the black box recorder, you know when it sounded, okay? So everything that I'm about to read to you is not speculation, it's not an estimation, it's actual numbers, okay? The number of actual feet to stop the train when the emergency brakes were applied is crucial, since defendant's expert affidavit states that the train was sounding its horn for at least 19 seconds before the train's brakes were applied. So we know that. At 29 miles per hour, the train would have been traveling at 43 feet per second, which means that the train was 817 feet behind Jacob Marion when the Oak Street crossing horn was first applied. 817 feet. Had the defendants applied the emergency brake at the same time as they sounded the horn, after observing the young boy walking on the tracks, for the time it took to travel 3/4 of a mile to a mile, the data recorder box reflects that the train would have come to a complete stop after the emergency brake was applied in 719.5 feet.
Yeah, counsel, can you address, your opposing counsel indicated that, you know, obviously the railroads are a highly regulated industry, right? And there are regulations that say no less than 15 seconds prior to a crossing and no more than 20. That makes sense, right? You don't want horns blowing their signals all over the place, sort of thing. But so her contention is that it couldn't have been done earlier, and therefore that presumption couldn't have dissipated earlier.
First time I've heard that is today. I'm going by what all the testimony's been in this case, including our expert affidavits and everything else, Your Honor. I can only say that Mr. Beal unequivocally says, and I'll quote from his deposition. Well, actually, I wanted to point out one other thing here, if you don't mind. Obviously, had they sounded the horn, had they applied the emergency brakes when they sounded the horn, especially after Engineer Wilson says, well, he's not responding, okay? This wouldn't have happened. It would have stopped several feet before they ever reached the boy, okay? And what also is important is it's not just when you get to the Oak Street crossing. It's just not that 20-second period here. We're talking about two people driving a locomotive at 29 miles per hour who sees a boy walking on the tracks in the same direction, and it takes them 2 minutes to get there. Not once, as they were approaching, did they try to sound the horns, blow whistles, do whatever it takes, just to see if maybe he would turn around and take a look and say, oh, there is a train coming, I better get off these tracks. He obviously didn't hear it because of the earbuds that he was wearing at the time.
But what if they, let's assume what she's saying, what if they were prohibited by federal regulation, let's just say, if they were prohibited from sounding a warning signal more than 20 seconds prior to approaching the intersection?
I can only say that Richard Beal, and I could quote him all over the place if you like, but he testified at length that these two people should have been sounding that horn way, way, way before. That 20-second rule would have nothing to do with approaching a street crossing. If you're a half a mile in front of it, you wouldn't even hear it if you're in a car a half a mile away, maybe. I don't know. But to try to maybe further clarify the answer for the court, he was specifically asked, and what is your criticism? And keep in mind, this is somebody with 50 years experience in this industry. The criticism is that both the engineer and the conductor stated that they could see this individual out on the tracks for 3/4 of a mile to a mile away, and that they were watching him constantly. They could tell you that he didn't turn around and look, and they didn't blow the whistle at all to try to warn this individual on the track. Rather, they just waited until it was time to start sounding the whistle for the crossing. And then just briefly, the best way I could put it was sounding the whistle for the crossing. In other words, that's when they were doing what they were obligated to do as they were approaching a crossing.
Your expert can't void a federal regulation. If the legal conclusion is the federal regulation says you can only do it between 20 and 15 seconds beforehand, and the law says there's a presumption that a person will get off the tracks, and you sound the horn at 15 to 20 seconds, that leaves a good bit of time for someone to step off of the tracks, right?
I can't stand here and say, because this is the first time this has ever even been mentioned, that federal law requires them to not touch the horn or the whistle, and no matter what's going on, no matter what's in front of them. I can't imagine that the federal regulations,
Well, okay,
when you're trying to protect human life.
Let's go about it a different way. Do you agree with the proposition that when the train crew saw Mr. Marion, that they had a right to presume he was going to leave the tracks before the train arrived and hit him?
When they first saw him, I would say, okay, you're a mile away. But as you are approaching at 29 miles per hour, you should start trying to do something, and that's what our experts said.
Is that a yes? I'm not sure what that is.
So,
Did they have it, when they saw him, I'm going to give you, even when they first saw him, did they have a right to presume he was going to leave the tracks
I would
before
say
the
yes.
train arrived and hit him?
I would say when they first saw him at a mile away, you're not going to put your emergency brakes on or start gearing down. But as you continue to proceed for a period of 2 minutes, yes, you should start to recognize that this boy is still walking on the tracks. So,
I'm not going to ask the next question because we didn't get past the first question. Go ahead.
I'm sorry.
No, go
Okay.
ahead.
Well, I mean, I was trying, with respect to answering, the 3 questions that were presented by the court, all right, she keeps saying that they ignored precedent, but the Court of Appeals did not ignore precedent. In fact, they talked about Lakeshore, and they talked about several cases that even predated Lakeshore. And the court was quick to point out, a Public Court of Appeals, was that in cases, it's not a guaranteed presumption automatically at all times, no matter what, because even in 1887, in Lakeshore, the court went on to say, in cases involving children or other people who give the train operators good reason to believe that he is otherwise insensible of danger or unable to avoid it, the train operator has no right to presume that he will get out of the way, but should act upon the belief that he might not, or would not, or therefore should not take means to stop the train in time. So that's
Wasn't that for very young children?
I'm sorry?
Didn't that apply to very young children?
Well, they actually, at the time of that case, there was a case with a 2-year-old, you're correct, that was actually laying on the
And then
tracks.
there were subsequent cases
And there
that
were-
were 9, 11, 13,
And
maybe.
and that was all, and again, the point of all that is that was during contributory negligence. And of course, the Court of Appeals opinion goes at great lengths to point out that everything, you really couldn't have a claim against a train when there was contributory negligence, because even in Lakeshore, it's a grown man driving a cart being pulled by horses across a set of tracks, totally different than what we have here. And
Counsel, just so I'm clear, are you claiming the horn should have been blown earlier than the 18 to 19 seconds? Is that how you briefed this case in our court?
that it's yes, because of our own experts' testimony, that nothing was done, absolutely nothing was done until they were obligated to blow a horn because they were approaching the Oak Street crossing. So they should have done something, yes, Your Honor.
Just so I'm clear, if I go and read your briefing in our court, you've made the argument that the horn should have been blown earlier in our court? I didn't understand that to be your argument.
Yes, in the court, yes, absolutely. In the original brief in the Court of Appeals, at length, we went over all of Richard Beal's testimony at length for several pages as to what they should have done. And obviously, the Court of Appeals relied upon that.
Are you also claiming at the 18 to 19 second mark, I guess I'm trying to understand this, that they had a duty not only to sound the horn, but they also should have applied the brakes at the same time? When under your sort of understanding of the duty, when did the defendants here have an obligation to apply the brakes?
According to the Court of Appeals opinion, which I totally agree with, using just common sense, what a reasonably prudent person would do under the circumstances then they're existing. It's probably not very often. This wasn't a situation of some kid playing chicken with the train, or in the Fry case, which I'll talk about.
I didn't follow your answer. I didn't follow your answer. When did the defendants here have a duty to apply the brakes? Is it your, don't you have a theory as to when they should have done that?
At the very, certainly I think it should have been before they even approached the crossing, yes. But even evidentiary-wise, had they applied it when they recognized he wasn't responding 19 seconds before, they wouldn't have hit him. So at some point you have,
I'm having trouble with that timeline, because at the 18 to 19 second point, when they sound the alarm, you're saying they should have applied the brakes at the same time?
in this instance, absolutely, because they have to, at some point, they have to recognize that there's a kid that's been on the tracks this entire period of time, and he hasn't once turned around or made any awareness whatsoever that a train's approaching.
But they're allowed to
So-
wait for the horn, right? I think I'm following with Justice Viviano. If we're within that 20 seconds, assuming we agree that that's what the regulation requires, it sounds like they sounded the horn and then they pulled the brake as soon as they could. Do you disagree there was a window of time they could have done it sooner?
Absolutely. They unequivocally, both the engineer and the conductor said that they thought it was maybe over 20 seconds when they applied the brake, but it's clear and unequivocal that it was 0.7 of 1 second. They applied the emergency brake at impact, 0.7 of 1 second. Their own expert said he thought it was 1.2 seconds. So I find that, and so does our expert, it's just appallable. It's reprehensible, quite frankly, to do that. I can tell you with great certainty, Your Honor, that that brake was first applied at 0.7 of 1 second before striking the boy. That's a fact. I think it boils down to, and again, you're looking at, a question of fact, okay, with respect to what all these people have said and what plaintiff's expert has said and what's reasonable under the circumstances. And, the Court of Appeals in the concluding paragraph, Justice Glacher said, exactly when defendants could and should have stopped the train represents quintessential fact questions. There's been never any discussion that they can't touch that horn until 19 seconds, until just now 15 minutes ago. So I can't give you an answer that's been briefed because I had no idea this was coming. And whether stopping in time was possible is yet another question of fact. When viewed in a light most favorable to plaintiff, the train crew saw Jacob from almost a mile away, and despite numerous horn blasts and the train's lights, which we all acknowledge were not activated until they were approaching Oak Street, that's never been in dispute, okay, recognized that Jacob did not change his course in the slightest. Nevertheless, the train did not slow, and its emergency brake was not applied until it was too late. This was not a sudden, unexpected trespasser who happened to cross the tracks. Rather, based on the testimony of record, a reasonable jury could conclude that defendants had Jacob in plain sight and recognized his peril for a period of time sufficient to react so as to not strike him.
If we assume it was reasonable or appropriate to sound the alarm at the 18 to 19 second mark, was it possible then for this chain of events to happen where the train conductor and the engineer have the ability to see if the person responds, and then under Lakeshore it appears then they're supposed to sound the alarm again and see if they respond and then hit the brakes? Or is it your claim that if they were right in sounding the alarm at 18 to 19 seconds, they had a sort of concomitant obligation to apply the brakes at that time too? I'm trying to understand what your claim is here.
I'm trying to say I'm trying to be in agreement with Justice Zara, where there isn't any law that says they could not have applied the horn and sounded the horn 40 seconds before. If
But
they
so-
did,
so-
and he
so
wouldn't
what-
have responded, Your Honor.
So
to it.
I just want to make sure I know what your claim is. So you're not,
I'm
your
not
claim
saying-
is they should have sounded the alarm before 18 or 19 seconds? That's what
Should
the
have,
claim
no,
is?
I'm claiming he should have. Just the opposite. They should have been doing something to at least
Well,
make.
you say doing something, I don't know
Horns
what
and
that,
whistles.
how many options do they have? They only have
Horns
a
and
couple
whistles.
options, right?
Horns and whistles, and he wouldn't have responded because he had earbuds on. They
Brakes,
said, okay,
horns,
he's
whistles, that's about it, right? I
Sounding,
don't-
yeah, well, that's, or slow down the train. Our expert also says
Yeah,
that. at some point.
brakes, horns, whistle. I mean, they only have a couple options, right?
Yeah, I mean, gearing down the train and trying to stop it, obviously, when they realize they may hit the boy. So, I mean, I've tried to answer everything the best I can, but I can't, I'm not saying, Your Honor, that it was reasonable to assume that it was okay to sound it at 19 seconds and only at 19 seconds. They sounded it because they were approaching a street crossing. They could have sounded it way before they got to the Oak Street crossing, anywhere between three-quarters of a mile and a mile. And I'm not saying they should have sounded the horn at 1 mile away, but at some
Okay,
point.
but in the alternative, my understanding is your argument to this court, so that they should have sounded the horn earlier.
Absolutely.
But even though they didn't, and let's say it was at that 18 to 19 mark, the argument is as soon they sound it, as soon as they see that he doesn't turn around, doesn't get off the tracks with 18 to 19 seconds before impact, that is when they put the emergency brake on.
Put it on 0.7 of a second before they hit him.
But
Sorry, did I misunderstand
What you're
you?
arguing that they should have done.
Oh, absolutely.
Is
Wait,
it
yeah.
should have been immediate, so there shouldn't have,
At
not
the-
have been a span of time between the horn before the crossing and him not responding, or, there shouldn't have been that 18 seconds.
At the very least. I mean, I think you have to look at the totality of any circumstances when you're trying to determine negligence and in common law of responsibility of any person. And you have to look at the facts of this particular case, and they are unique. They see a boy walking down the tracks in the same direction, and had they have done something, they would have recognized that he wasn't responding, and they could have said, okay, we better stop the train. I mean, I think you have to look at the facts, all the facts, and in this case, when you do so, it's clearly, in my opinion, a situation where any jury would be able to conclude that they did not act reasonable. Not applying the brakes when you hit them. 0.7 of 1 second, that's no excuse, okay? Had they applied it even 1 or 2 seconds after they sounded the horns, the train would not have been going 29 miles per hour. I can't tell you what the end result would have been, but he wouldn't have been hit at 29 miles per hour. I hope I tried to answer the questions the best I could. Anything else? I have 1 minute and 44 left, but I don't think I need to add anything.
Further? Thank you very much.
Thank you. Thank you.
I have 1 minute and 44 seconds.
How much time?
1:45.
1:54.
Sorry.
Can I ask just real quickly, because I was looking, is it a federal regulation or a federal statute? So it's CFR, because, and can you show me, was it cited in any of your briefs?
It was, yes. Forgive me, but there's been a lot of briefing. Yes.
Yeah, because I just pulled them up, and I didn't see I didn't
Can
see a
you-
cite to the CFR.
Yeah, sorry. Can you use them? Yeah.
So could you repeat it for me so that we can look at it
49
now?
CFR 222.21, lowercase b, 2. The locomotive horn shall begin to be sounded at least 15 seconds, but not more than 20 seconds. But very importantly, as my colleague wanted me to point out for Justice Zara, to answer your question, 222.23, so the following section, says that a locomotive engineer may sound the locomotive horn to provide a warning if in the locomotive engineer's sole judgment such action is appropriate to prevent imminent injury, death, or property damage. It's in the engineer's sole discretion pursuant to federal law. It's not Mr. Beal's decision, it's not the jury's decision, it's federal law has said the engineer, it's his sole
Well,
judgment.
why isn't it a question of fact, then, of whether he exercised that discretion reasonably?
Well, because of the right to presume, but I just want to point out, with
Okay.
regard to Michigan law,
Okay.
my partner said to Mr. Beal at his deposition, are you aware that Michigan law says there's a right to presume? And Mr. Beal at his deposition says, page 43, I don't care what Michigan law is. He doesn't care what the federal law is either. He also testified.
So let's go back to that CFR that you just cited. I guess I'm confused on why that matters. It doesn't say that it says within this period of time before a crossing. It doesn't say you can't blow the horn if there's imminent danger.
Right, but the federal statute says it's his sole discretion.
But you're just now bringing that up. Before when you were up here, you kept talking about this federal regulation and that they could not have blown the horn before this period of
Right.
time before the crossing. Nothing says that they cannot.
Right, but the federal statute imposes into the engineer the sole discretion as to,
Correct, and so why isn't it a question for the jury to decide whether that discretion was exercised reasonably?
because of the right to presume, that unless it's apparent that he's not going to step off,
And when-
he has the right, they have the right to keep going. That's the law this court has established upon which the crew relied. And whether Mr. Beal cares about the law is disturbing to me. But what is also disturbing to me.
I'm sorry, your time is up. Does
But
anyone?
can I just ask a very quick question?
Yes.
I think what everybody's just really trying to get to here is, why didn't he blow the horn? We understand it's discretionary that he can or cannot, but what would the harm be in blowing the horn? And why shouldn't that be, as Justice Zara mentioned, a question for a jury?
Well, throughout the country, there are quiet zones that prohibit railroads from sounding their horns.
No, I understand that, but there was a person on the track. So I guess the question here is, you have a braking system, you have the horn. Why wouldn't you just, if there's a young man on the tracks, you see the young man on the tracks, why wouldn't you just blow the horn?
Well, because-
I understand the issue of the quiet zone, but I think that gets outweighed by the fact that there's a person on the track.
Well, because this court has established the right to presume.
Okay.
Your Honor, if you have a pedestrian walking ahead, you have the right to presume they're going to get off. If you have a car approaching the crossing, you have the right to presume they're not
No,
going
I
to put
understand.
themselves in danger. A jury is not entitled to go beyond what this august body has said for 100 years, that the crew has the right to presume, and unless it becomes apparent, there's no duty to take evasive action, including sounding the
Thank-
horn.
Got it.
That's why it's not a jury question.
Thank you,
Okay.
thank you
Thank
very
you
much.
so much,
Your
Ms.
time is up.
I appreciate your
And
time.
the case will be submitted. Thank
I
you.
appreciate your patience, all. Thank you.
Thank you.